Good afternoon. I'm Robert Strassfeld, a member of the faculty here at Case Western Reserve University School of Law. And I want to welcome you to the annual Rush-McKnight Labor Law Lecture. In 1997, the law firm Calfee, Halter and Griswold and Richard Cusick, Charles Emmerich Jr., and Joseph Sullivan created this lecture to honor retired partner Rush McKnight. A distinguished 1955 graduate of our law school, Rush McKnight headed Calfee, Halter and Griswold's labor law and employee relations practice, and also served on the executive committee for many years. He is both a civic leader in the Cleveland community and a dedicated supporter of our law school. We are proud to host this lecture in honor of Mr. McKnight and sincerely thank the members of Calfee, Halter and Griswold and the other donors who have made this lectureship possible. This lecture is presented under the umbrella of the law school's Center for Interdisciplinary Study of Conflict and Dispute Resolution. The law school created SISTER in 2005 with a mission to foster scholarship that will bring about a greater understanding of traditional and innovative methods of conflict resolution, will inculcate in our students a greater sensitivity to alternative dispute resolution, and will give them the skills necessary for the multiple roles they will play as lawyers. Because labor law has provided some of the foundational theory and experience in this area, it is fitting that the Rush McKnight Lecture be presented under the auspices of SISTER. I encourage you, incidentally, to pay attention to the law school's calendar. This is one of a series of lectures presented by SISTER, so please keep your eyes open for future lectures upcoming. Some of you, probably most of you, may have noticed that suddenly your friends, your neighbors, perhaps your sister, brother, cousin, who are public employees have become, in the eyes of many, the devil incarnate. We thought this was something that merited more discussion, a closer look. How is it that suddenly public employees have become those whose names shall not be mentioned in our political discourse? When we talked about who would be the appropriate person to come and talk about the assault on public sector unions, Joe Slater was the name that immediately came to all of our minds, those of us who were charged with planning this event. Joe Slater is the Eugene and Balk Professor of Law and Values at the University of Toledo College of Law. He earned a BA in history from Oberlin College, then went on to the University of Michigan, where he earned his JD, and then subsequently a PhD in history from Georgetown University. He practiced labor and employment law in Washington, D.C. for over a decade, I read, before seeing the light and finding his way to academia. He has written extensively both on labor law history and on contemporary issues in labor law, not exclusively on public sector employees, but there is nobody more fit and able to address public sector unionism, about which he is the author of multiple books, than Joe Slater. I will now be quiet and get out of the way and introduce Joe Slater.
Thank you, Professor Strasfeld, for that wonderful and probably overgenerous introduction. My name is Joe Slater, and I am a public employee. And we'll start with that, the University of Toledo College of Law. I am very honored to be here at this law school, this excellent law school with a terrific reputation nationally in all fields and a fine reputation in labor and employment law, not least because of people like Professor Strassfield and Professor Murphy. I am very honored to be part of this lecture series. I have taken great interest in it in the past, and when I think of the names that have been associated with it, I am truly and genuinely humbled. And I attribute my presence here today to the rather sudden and unexpected prominence of the area that I and about 3 people besides me in legal academia specialize in, public sector labor law. But I have been trying to convince people for some time that public sector labor law is important, and I have argued, among other things, since 2009, over half of the union members in the U.S. are members of public sector unions, which is a product of the diverging union density rates in the private sector, around 7%, and the public sector around 40%. And I've been trying to interest people in the theoretical issues. Public sector labor law, as I'm sure at least most of you know, is state law and not federal law. And as state law, it varies dramatically from states where public employees have no rights to bargain collectively at all, to states where they have rights to bargain but not about much, to states where they have rights to bargain about a lot of stuff but they can't strike, to states like Ohio where they can bargain about a broad variety of things and can strike. So it's a fascinating issue intellectually. I've been reminded in events like this of an event that I attended when I was in college, and this will date me. This was around the time of the Iranian Revolution, when the hostages were taken and all that, and this being Oberlin College, and I know probably most of you are familiar with Oberlin, of course, we had to have a teach-in about that. And at the teach-in, I saw this old professor from the religion department, who I'd never paid any attention to before, get up and say, you know, I've been studying this issue, Shia Islam, for my entire career. No one has ever been interested in it before. Now they're interested in it, but I can't say I'm happy about the reasons why they're interested in it. And I have become this old man because I am now, on the one hand, happy that people are interested in public sector labor law and history and policy, but I cannot say, speaking for myself personally, that I am happy about the reasons that this has become a hot issue this year. The wave of laws in 2011 which have radically restricted public sector union bargaining rights. And what I am going to do today is argue that these laws are misguided. I will describe them in some sense, and I will also argue that public employees are not overpaid, that these laws are not about improving or streamlining or making public sector labor law better, and that they will not improve public services. They are primarily done, I am sorry to say, for partisan political purposes. The first thing I'm going to talk about, however, has to do with the history of public sector labor law, because I think to understand where we are in 2011 or now 2012, we have to talk about what happened way back in 1919, because U.S. public sector labor law developed on a very different track than U.S. private sector labor laws. I'm sure at least most of you in this room know, in the private sector, most workers got the right to bargain, to form unions, to bargain collectively, and to strike with the National Labor Relations Act in the mid-1930s. There was no statute in the U.S. that gave any public employees at all the right to bargain collectively until Wisconsin, ironically, given recent events, Wisconsin passed a law in 1959 and 1962, but this is already several decades after the NLRA. The Ohio law was not passed until the early 1980s, almost half a century after the NLRA. And the question is, why is that? And I don't think we can take it as natural or obvious that public sector labor law has to be something different than private sector labor law. Indeed, if you look at the laws of Canada and most European countries and most Western industrialized democracies in general, public sector labor law is in fact fairly similar to private sector labor law. It is possible the police won't be able to strike or firefighters won't be able to strike. But I was asked a question earlier today. In Sweden, the military, the actual soldiers, can unionize. So it's not necessarily, and you might say, well, how many wars do they get into? But still, the point is that public sector labor law in much of the world, most of the rest of the world, is pretty much the same thing. There wouldn't be a separate class, as there is in my school, in public sector labor law in any of the Western European countries. So I think the U.S. is the exception rather than the rule in this case, and the question is, why is that? Well, I wrote a book explaining that, and I'm not going to recount every argument in that book today, but I think there are several reasons. One of the most important reasons was the Boston police strike of 1919. This was a very dramatic event. Interestingly, the cause of the strike was the insistence of the Boston police officers of affiliating with the organized labor movement. They had essentially a company union. The company union was not getting them the results that they wanted. They said, hey, let's affiliate with the AFL, the American Federation of Labor, at the time. That will give us more power. The police commissioner at the time, a man named Edwin Curtis, said, no, you can have an unaffiliated employee organization, but you cannot have your own union, or you cannot have a union that's affiliated with the AFL. The police officers insisted. They wanted to stay affiliated with the AFL. The police commissioner suspended the leaders of the union because they refused to renounce their affiliation with the AFL. And in reaction to the suspensions of the union leaders for their insistence on staying affiliated with the labor movement, the police went on strike. And when I say the police went on strike, I mean over 1,100 cops went on strike. This, as you cannot imagine, did not have happy results. There was a lot of violence and crime and looting. Several people were killed. Hundreds of people were injured. Lots of property was damaged. There was an image of lawless Boston until Calvin Coolidge sent in the state police. Calvin Coolidge, by the way, rode this issue into national prominence, but that's another story. So for a long time after this, the enduring image of any form of public sector unions in the U.S. was of the Boston police strike. And after the Boston police strike, an early wave of public sector organizing was crushed because cities and police departments and fire departments and school boards and other local employers across the country simply banned unions from their agencies. They enforced yellow dog contracts as a condition of working for this school board, working for this police department, working for this city maintenance department. You cannot be a member of a union. Those of you that know the history of labor law will recall that in the private sector, yellow dog contracts were banned in the 1930s. The Norris-LaGuardia Act did not apply to the public sector. And these yellow dog contracts continued in force into the 1960s. And it was then and only then that the Supreme Court found a constitutional right to at least be a union member in employment. But they didn't even have that before the 1960s. Judges, policymakers, other people involved in labor relations continued to see public sector unions through the prism of the Boston police strike, even though public sector unions routinely vowed that they would not strike, even though between 1919 and the 60s or 70s, public sector strikes were rare and short and undramatic generally. The image was if you had public sector unions, they were going to strike, and if they were going to strike, it would all be as disastrous as the Boston police strike. And I'll give you a couple of quotes from cases. In two separate cases, decided in the 1940s a decade after the NLRA was passed, and one would think that public sector union relations would be somewhat normalized. A decade after the NLRA was passed, two separate state courts, one from New York and one from Texas, used the following quote: in cases where the union was only asking for the right to be able to organize, to be able to be a union member without being fired. They weren't asking for the right to strike, certainly. They weren't even asking for full formal collective bargaining rights. Two different courts used the following quote: to tolerate or recognize any combination of employees of the government as a labor organization or union is not only incompatible with the spirit of democracy, but inconsistent with every principle upon which our government is founded. Every principle, the court said. Contributing to the lack of a public sector labor law in this era was the strong federalism notions within the U.S. Constitution, something we are reminded of today in the arguments over the Affordable Health Care Act. It seemed pretty unlikely that a law that purported, a federal law that purported to give collective bargaining rights to public employees would have passed 10th Amendment scrutiny back in the middle of the 20th century. It's not 100% clear to me that such a law would pass 10th and 11th Amendment scrutiny today. So you had no federal law, you had state and local lawmakers who were constantly associating the concept of public sector unions with strikes, and this helped delay the development of public sector labor law. This long period of lack of collective bargaining laws, however, was still marked by unions actually organizing. Public sector unions organized. The American Federation of Teachers was formed in the second decade of the 20th century. So was the International Association of Firefighters. AFSCME was formed in the 1930s. You had all of these major players of unions that were there, and they were actually organizing employees on the ground, and they were actually doing some collective bargaining or informal collective bargaining because they had no formal right to bargain. This was generically known as the era of collective begging because there were no formal rights, but there were employers, public employers, who would negotiate deals with unions, and you still see this sort of behavior today in states where there is no legally authorized collective bargaining, Virginia, North Carolina, South Carolina, for example. This era began to end, the beginning of the end came in 1959 in Wisconsin, which again, ironically, was the first state to authorize some limited forms of collective bargaining for public workers. This was a long battle. The Wisconsin legislature met in odd numbers of years, and proponents of a collective bargaining law in Wisconsin proposed a bill to provide collective bargaining rights and lost in 1951, proposed a bill to provide collective bargaining rights and lost in 1953, same in 1955, same in 1957. Finally, in 1959, a Democratic governor was elected. Democrats controlled both houses of the legislature for the first time in a long time. This is the sort of the history repeating or reversing itself or something like that. As a history PhD, I should have a more technical name for it. But anyway, labor law, public sector labor law has often been political, let's just say that. And finally in 1959, they passed the first statute that gave public workers, municipal workers in Wisconsin, the right to organize into unions and to engage in some collective negotiations. They couldn't strike, and it wasn't clear that if the employer and the union disagreed, the union had much of a right to do anything about it, but it was a step forward. To compress the next couple of decades of history, what you see is two things, one of which is a number of other states following a model of granting collective bargaining rights to public sector workers. You see 16 states by 1966 adopting these laws, By the 70s, a majority of states had adopted these laws. Ohio finally gets in on the action in 1984. Today, or even by the mid-80s, a clear majority of states gave some or all of their public employees the rights to bargain collectively. You also see a working through of some of the tough issues. Should public employees have the right to strike? Well, that's what labor unions do, right? Well, alternatives began to develop in the public sector. Mediation, fact-finding, arbitration. And again, today there is a whole host of variations in different states about how all of these work. Is mediation mandatory or voluntary? Is fact-finding mandatory or voluntary? If you have arbitration, is it mandatory? Is it voluntary? Is it binding or is it advisory? If it's binding, does the arbitrator have to pick one of the final offers of the two parties, or can it be a compromise in the middle, final offer arbitration versus conventional arbitration? And there's many variations within that. There's also many wonderful variations in public sector labor law about what unions can negotiate over, what we call the scope of bargaining. In states like Ohio, it's fairly broad. Many of the same things that private sector unions can negotiate about, although not all, notably not pension benefit formulas, but many other things public sector unions can negotiate about. In the federal sector, most employees of the federal government outside the post office are not allowed to negotiate about compensation issues at all. Early on in my career, I was given the job of negotiating a contract for a federal sector union, and I looked up the law, and they said, you can't negotiate about compensation. I thought I realized why they gave me this job, so I couldn't screw anybody's, pay up. But it turns out that you can negotiate over a myriad of other issues having to do with workplace conditions, promotions, anti-discrimination procedures, and the like. And I think that what we have seen throughout the arc of public sector labor history is a desire of workers to have some voice in their workplace. Public sector workers organized when they had no right to bargain collectively, when they had no right to be in a union. Public sector workers organized in the federal sector where they can't negotiate about pay issues because they want to talk about other sorts of things. And it is a nice example of law not necessarily dictating reality on the ground. So, we have had all of these interesting variations in law, and part of me would love to talk to you just about that today, but I feel obliged, because of the events of 2011, to talk about what happened in 2011. Because although public sector labor laws did change, and sometimes they would be expanded and sometimes they would be contracted around the margins in different states, and Michigan would pass this law saying teachers couldn't negotiate about a couple of things, and New Mexico would grant that law saying their employees could bargain when they previously hadn't bargained before. And you would see some expansions and contractions like that. Nothing in the previous 50 years prepared us for what happened in 2011. I have actually given a 45-minute talk just describing all of the different laws that were changed in 2011. And if anybody has any particular questions about any particular state, I will tell you that there were bills passed in Wisconsin, Ohio, Idaho, Illinois, Indiana, Massachusetts, Michigan, Nebraska, Nevada, New Hampshire, New Jersey, Oklahoma, and Tennessee, all in 2011, all substantially changing collective bargaining rights. This isn't even talking about laws changing pension rights. There were 44 states that did that in 2011, and no, I'm not going to list them all. But there were 13 states that changed significantly their laws on public sector bargaining. So if there's any questions, for example, if one of you is particularly curious about what Idaho did, I would be happy to talk to you about that in the question and answer period. But I'm going to focus in my talk primarily on what happened in the two most radical states' revisions, Wisconsin and Ohio. My first point about these laws is to note that they had a certain partisan tinge to them. Didn't know that was going to be a laugh line. Anyway, there's a certain partisan tinge to them, and I think perhaps most famously, the law that eliminated collective bargaining rights for most employees in Wisconsin, or effectively eliminated collective bargaining rights for most employees in Wisconsin. They have some residual rights that are hardly worth calling collective bargaining rights. That this law did not apply to police and fire unions. And the conventional wisdom there is that police and fire unions traditionally support Republicans much more frequently than they do Democrats, and even when the actual unions themselves don't support Republicans explicitly, the membership is more likely to support Republicans explicitly. Another indication of, I think, the partisan nature of some of these laws was the fact that in Wisconsin and Ohio they were right-to-work laws. As most of you know, right-to-work means that it is illegal for an employer and a union to enter into what is called a union security clause. A union security clause meaning an obligation of a member of a union bargaining unit to pay at least those portions of his or her dues that go to the union's activities relating to collective bargaining. And the reason that collective bargaining laws, or the reason, excuse me, that right-to-work laws have been critiqued is that unions have a duty of fair representation to their members of the union bargaining units that they represent, to represent individual workers whether or not those workers pay dues to the union. So in a right-to-work jurisdiction, and again I think back on my days representing federal employees, which is also a right-to-work jurisdiction, you can have a person who is a member of the union bargaining unit who is not paying dues say, hey, I just got fired, I want the union to represent me. Or hey, I want in on that raise that the union just negotiated, and the union has to treat that person just as if they were someone who was paying dues. So it's right-to-work creates sort of a classic free rider problem that would be recognized in most other circumstances, but also for this purpose it seems much more logical to explain right-to-work laws as an attempt to cripple unions financially than it does to try to argue that this improves the collective bargaining process. They are trying, I think it was a partisan attempt to take away resources from unions because, again, unions have to provide the same coverage whether they get money or not. And as I often say, I like my cable company fine. I think it gives me a decent number of channels for what I pay for them. But if the law were such that it would have to keep providing me that cable service without me paying them any money, I might not actually pay them any money. And it turns out that's what happens in right-to-work jurisdictions. Nothing to do with state budgets, a lot to do with crippling unions financially. Also, the Wisconsin law had an unprecedented mandatory recertification procedure. As those of you that know labor law know that generally in labor law, private sector and public sector labor law, the rule is if you have a certain percentage, usually a third, of the bargaining unit that wants to have a recertification election to try to kick the union out or replace it with some other union, well, you can get one of those, or you can at least get one every 3 years. Wisconsin would require a mandatory recertification, or not, I shouldn't say would, does, Wisconsin law now does require a mandatory recertification system every year. And in order to be recertified, the union has to receive at least 51% of the votes, not of everyone voting, but of everyone in the bargaining unit as a whole. So imagine you have, for example, a bargaining unit of 400 people. Nobody asks for a recertification election, but one is scheduled automatically every year. imagine further, in this recertification vote, the vote is 201 in favor of keeping the union, 100 opposed to keeping the union. The union is now decertified because 201 is not 51% of 400. This is not, I suggest, a rule designed to improve collective bargaining, but rather, or improve state budget situations, but rather a rule to cripple unions, to make it not worthwhile to maintain certified status, especially given that in Wisconsin now the only thing unions are permitted to bargain about is wages, and wages only up to any rise in the cost of living. So if you were a union or someone considering paying dues to a union, would it be worth it to go through this recertification process? A number of unions in Wisconsin, I think, have rationally decided, no, it's not. And again, I think this is not so much about state budgets, but rather about destroying an institutional supporter of the Democratic Party. SB5, the late, not so lamented SB5 in Ohio, would have done some similar things. It would have imposed a right-to-work rule, again, without changing the rule that unions are required to represent all members of a collective bargaining unit, whether or not they want it. They would have, or whether or not they're paying dues, excuse me. Similarly, SB5 would have made it more difficult for unions to get employees and employers to agree to dues checkoff for union political action committees. SB5 would have also done an interesting thing to impasse resolution procedures. I mentioned earlier that that was a huge issue in the history and development of public sector labor laws. What are you going to let these people do if they don't strike? Well, Ohio had let at least most of its public employees strike, and for those employees who you really don't want striking, like police and fire, that had binding interest arbitration after fact-finding and mediation, SB5 would have replaced that with a system that just had mediation and fact-finding, and after the fact-finding had concluded, to make a long story short, the employer under SB5 would have been authorized essentially to pick its own proposal, and that would have been it. And as I sometimes say, this is sort of like the bargaining that I do with my 8-year-old son, where he says, I want to play the Wii for an hour, and I say you can do it for another 10 minutes, and he says, no, really an hour, and I say, you know what, I'm choosing my proposal, 10 minutes. That's not, however, an effective, I believe, method of collective bargaining. And of course, these and other laws did much more than this, but it was all designed to cripple unions, I think. And the examples I gave were meant to point out that this was not really about state budgets. Along those lines, eliminating or restricting collective bargaining rights does not seem to have, in general, any positive effects on state budgets. I'm going to make the following points. I'm going to argue that public employees are not overpaid relative to private sector employees. Second, to the extent that there are problems in the compensation of public sector employees, and there are some, these mostly focus on pension benefit formulas. It is in fact true that there are some public employees, and I say this with reluctance because I'm a public employee myself, but there are some public employees in the country who have overly generous, or at least pretty arguably overly generous, pension programs. But again, I said this before and I want to stress it. Crucially, under almost all public sector labor laws, including the labor law in Ohio, including the pre-existing labor law in Wisconsin, and in most of the other states that I mentioned, in all but 3 states in the union, pension benefit formulas are not a legal subject of bargaining in the public sector. The fact that someone has a fat defined benefit pension plan, well, you know, this Joe down at the Jeep plant just has a chintzy defined contribution plan that's tanked when the market tanked. That may be a problem we can look at, maybe a problem we should look at, but it's not a product of collective bargaining. Pension formulas are set by state statute in Ohio, Wisconsin, and most other states, and have nothing to do with collective bargaining. So, in a little more detail, public employee compensation. There has been a lot written on public employee compensation, and I am not an economist, and I'm not going to bore you with a lot of econometric studies. But I will try to summarize what I think were basically the three waves of studies on public sector compensation. The first wave was to say, look at the median employee in the public sector and the median employee in the private sector. The median employee in the public sector gets paid more. And that's true at other pay bands. Look at, the top 80% level, 80 to 90%. Public sector is here, 80 to 90% in the private sector is here. Public employees are overpaid. Not that simple, because the next wave of studies, that were debunking the first wave of studies, pointed out that you have a rather different set of jobs and employees in the public sector. If you were to go into the faculty lounge of this or any other law school, you would say, hey, the median salary here is much higher than the median salary out in other areas of Cleveland. But that doesn't tell you anything, because they're doing different jobs. And indeed, in the public sector, you have a much higher percentage of white-collar and professional jobs, and in the private sector, you have disproportionately, compared to the public sector, lower paid service jobs. So what the second wave of pay studies showed was that if you look at people actually doing the same job, people with the same skills, training, education, and experience, it turned out that public employees, even counting pension benefits, were somewhat underpaid relative to private employees. Now, that was not true at the very bottom. Public sector janitors might do a little better than private sector janitors. But in the middle and at the top, comparing apples to apples, the second wave of studies concluded public sector employees are generally underpaid. The third wave of studies, and I'm sure there will be a fourth and a fifth, but the third wave of studies said, oh, but wait. Yes, it turns out that public employees, if you just count the money the employer is giving them, are usually underpaid. But you need to count in some other factors, most importantly, job security. And it is true, if you assume public employees have job security that is worth 15 to 20% of their income, then they're overpaid again. The difficulty is trying to get a real number for how much we should value job security. Are public sector jobs all that secure? From November 2010 to November 2011, there were 251,000 jobs lost in state and local government employment. So it's hard to value this precisely, and even still, it's not related to collective bargaining, because almost all public employees who are eligible to be in unions would have just cause discharge protection anyway, because they would be covered by civil service statutes, in the case of some school employees, tenure statutes and all, are also. And these civil service protections and these tenure protections are, again, not a product of collective bargaining. It's illegal for unions to negotiate about tenure rules or civil service rules. And if collective bargaining disappeared tomorrow, you would still have these protections. Because of these reasons, it is not surprising that studies that have looked for correlations between state budget deficits and collective bargaining have not found a significant correlation. If you look at all of these states that allow public sector collective bargaining, on average they have state budget deficits of about 14%. if you look at the states that don't allow public sector collective bargaining. And by the way, this is one of the reasons why public sector labor law is such a fun area to study, because you can do actual comparisons. There's a bunch of states that allow collective bargaining. There's a handful of states that don't. Let's see how all that works. We don't have to have an argument completely in theory. States that bar collective bargaining have on average a 16.5% deficit, which is 2.5 points above the average of states that do allow collective bargaining. For example, Texas has one of the highest state budget deficits in the nation. It generally bans public sector collective bargaining. Nevada does not permit state employees to bargain collectively. It has one of the highest state budget deficits in the nation. North Carolina, which not only does not permit or legally authorize collective bargaining, but actually says collective bargaining is illegal for public employees. North Carolina is running a projected deficit of 20% for 2012. Ohio had a projected deficit of 11%. Wisconsin, before it amended its law, had a projected budget deficit of 12.8%. This is not to say that there are not real budget deficit problems, but rather that they were not caused by public sector collective bargaining. They were caused by the housing crisis and the stock market downturn, to the extent that there is, again, a compensation problem for public employees contributing to the deficit. It's in pension formulas. Because when you have defined benefit pension plans, you make certain actuarial assumptions about how much money you have to put into the plan to fund the future retirement benefits. When a stock market crashes, your assumptions turn out to have been horribly wrong, and now you have a huge shortfall. It does not help that the laws regulating state pensions and what types of actuarial assumptions they can make are not as rigorous as the private sector laws governing this. So there is a real problem. I think it can be addressed, however, not so much with taking away the collective bargaining rights of working people, but rather to maybe make some adjustments to pension formulas, as again about 44 states have in the past year. And beyond that, I just want to say personally that I think that announcing to cops, teachers, firefighters, the sort of people that take my recycling away in my office at the Toledo Law School, to say, you know, we are going to balance the budget on your backs, is unfair. And some of the rhetoric around SB5, I think, was fairly insulting. The rhetoric that says just because your employer is an arm of the government, you are somehow not a real or authentic worker, but rather some form of bureaucratic parasite. One of the more encouraging things, to me at least, about the rejection of SB5 was the rejection of that sort of rhetoric. I'm now going to turn, in the few minutes I have, to talk about the good things that I believe public sector collective bargaining can accomplish, because I think advocates of public sector bargaining, like myself, cannot be trapped in a constant defensive mode where we say, well, they're really not overpaid and it's really not crippling your budget. We have to make an affirmative case for why this is good. So let me give you a couple of facts or a couple of observations. Collective bargaining laws tend to reduce strikes, and nowhere in the country was that more notable than in Ohio. This is somewhat counterintuitive. Before 1984, all public employee strikes in Ohio were illegal. After 1984, most public employees, after going through certain procedures, did have the right to strike. Usually in the law biz, when something goes from being entirely legal to being mostly legal most of the time, we say whatever activity you're talking about is going to increase. This was not the case for strikes in Ohio. Law took place in 1984. From 1984 to 1992, there were 110 strikes in Ohio. From 1974 to 1979, a shorter period of time, and I'm using these years because they're the only ones we have data for, but a shorter period of time, there were 282 strikes. This means that legalizing strikes resulted in a reduction of strikes of about 75%. Why was that? Again, it's counterintuitive. You make something legal, you normally expect to see more of it. Because what collective bargaining does is it provides an effective way for employers and unions to sort out their differences without resorting to desperate measures like strikes. Before a public sector union can go on strike in Ohio, it has to go through mediation. It has to go through fact-finding. The threat of a strike makes the parties involved in these processes take them seriously, and they do take them seriously. And more generally, this effect has been found in other states, that when you have collective bargaining laws, robust collective bargaining laws, such as Ohio, such as Illinois, such as other states, you will see a decrease in strikes. I also think that advocates of public sector collective bargaining need to stress that bargaining can help public services be more efficient. When workers have a voice in how their work has being done, that can lead to more productivity. And indeed, studies on the effects of unions and productivities often show that unions bring higher wages and higher productivity. We want to have good, skilled people going into public service. It is, of course, true that if we paid all of our cops and teachers and firefighters the minimum wage, there would at least be a short-term savings in cost. But we don't want that. We want highly trained, highly skilled, motivated people in the public service, and we need to pay them competitive wages to do that. This is an argument that those who oppose union rights would often acknowledge in a different context. You often hear, well, if we pay certain executives less money, or if we try to cap executive pay, that will result in fewer good people wanting to go become CEOs. Well, the same is true of teachers. The same is true of cops. The same is true of firefighters. Public sector unions and public employers have often worked together to increase efficiency. I will tell you one story from my hometown of Toledo, where I have had an experience, a positive experience in this. The Toledo Federation of Teachers, like a number of other American Federation of Teachers locals across the country, has entered into an agreement, in its collective bargaining agreement, with its employer, the Toledo Public School System, that has a program to identify and try to help struggling teachers. In this program, if the union representative in a particular school building and a principal identify certain problems with a teacher, they can be placed into a mentoring program, at which point two things can happen. They are mentored by a senior teacher, and they either get better and they are restored to their previous statute, or they don't get better and they leave the teaching service. This is the sort of thing that I think unions can do. Teachers' unions have been attacked regularly. I understand there's some issue with the teachers' unions in Cleveland right now. I am not competent to speak about it, but I will say that the data shows that students in unionized schools do as well or better as students in non-unionized schools. Collective bargaining laws help the economy as a whole because they help the working class. When I think about my son and the problems that he will face in his life, I think about the increased wage inequality that we are facing. I don't need to tell you historic levels of wage inequality in the U.S. Very interesting new study, links explicitly at least a sizable chunk of the increase in wage inequality in the U.S. to the decline of unionization rates in the U.S. I will conclude with this. Unions and collective bargaining allow workers to have a democratic voice in their workplace. Having a democratic voice in your workplace, I would contend, is an important part of having a democratic society. Unions and participation in unions are a vital part of our democracy and a vital part of our economic health. I used to represent unions. I represented them, as Professor Strassfeld said, for over a decade. So I know they're not always right. I don't over-romanticize unions. I represented unions in cases where I thought they were wrong. I also, however, practiced long enough to know that managers and employers are not always right either. Collective bargaining allows a somewhat equalized voice in the employment and in the entire society as a whole. For these reasons, I'm happy that the voters of Ohio rejected SB5, and I hope it will be a turning of what has been a rather interesting and long tide. Thank you very much.
We have a little bit of time for questions. I'll ask you to please come to the microphone because you are being recorded. And we'll eventually find your way onto our webpage.
Yes. You said that the law says that you can collectively bargain but not strike, but a strike is a deterrent against low wages and disagreeable working conditions. So if people can collectively bargain but not strike, what other deterrents might they have? I mean, I can think of slowdowns, calling in sick en masse, and insubordination. I mean, what tactics could a union have to act as a deterrent against low wages and bad working conditions?
That's a great question. That's the question that's been essentially haunting the whole history of public sector labor law. I do want to be clear. Most public sector workers in Ohio still do have the right to strike, and workers in about 10 other states, public sector workers, most of them do have a right to strike. But the majority approach, even in states that permit collective bargaining, is to prohibit strikes by all public employees. For example, that's true in Michigan. And even in states like Ohio, some public employees can't strike, police and firefighters. So your question is, so what can they do? Because you want to have pressure. The answer to that traditionally in the public sector has been binding interest arbitration, where you go in front of an arbitrator and one side makes its case, the other side makes its case, and the arbitrator, a neutral arbitrator, under statutory guidance, giving factors the arbitrator has to consider, issues a binding order that says, this is what you will be paid, this is what your anti-discrimination clause will look like. It's a very interesting system, and I would only say that before all this stuff happened in 2011, I was interested in writing something, which I never got around to, about proposing this as a possible tool in the private sector, because the private sector right to strike has now become so eviscerated through the ability of employers to permanently replace economic strikers, that it's not clear to me that the strike weapon is as good an idea or as valuable to workers and unions as people once thought it was. But you're absolutely right to say you need something else, and the public sector answer to that has been binding interest arbitration.
Do you believe the results of the vote on SB5 would have been any different had the police and fire been excluded from coverage of that act?
That's a terrific question, and while of course I don't know, my guess is yes. If you look at the ads that were promulgated, at least the ones they were showing around Toledo, often the people taking the lead in these ads were cops and firefighters. Some have suggested that the reason that Governor Walker in Wisconsin excluded cops and firefighters was for political reasons, because he thought it would be easier to get something passed if it didn't hurt cops and firefighters. So although I don't know, and the vote was so overwhelming that you could say, well, you could take 10 percentage points off and it still would have failed. But I would guess the vote would not have been as dramatic as it was.
This isn't going to be an exciting question.
Well, then I'm not going to give you an exciting answer.
Is public sector labor relations in the federal sector still ruled by executive order or by legislation?
It's ruled by legislation. There is a federal service. You are right that originally it was an executive order. It came actually a couple weeks after the first Wisconsin law. It became statutory under President Carter.
Okay, thank you. I worked under it before that.
Yeah. And for what it's worth, I do think that's an interesting question.
I was going to ask, Professor Strassfeld kind of knows me. I'm actually in the history department, and I'm doing a dissertation on this kind of stuff.
Excellent.
And I'm focusing kind of on the 1960s. And it seems like, is it possible that in education, these ideas like the Toledo Federation of Teachers helping restructure contracts to improve would be much better served if the scope of bargaining were, I would say, statutorily broadened, so that wide issues of scope could be contracts rather than a focus on wages, benefits, hours, and conditions of work?
Yeah, that's a fascinating question, and it has a long answer, and I'd be happy to talk to you about it more afterwards. The short version of the answer would be this. Scope of bargaining in the public sector is a tricky issue. What can unions legally negotiate about? Because what you're trying to balance is the workers' interest in negotiating about wages, hours, and working conditions with the idea that there needs to be some democratic accountability for the acts of public agencies. So the traditional response to your question would be, well, what you have to worry about is letting teachers negotiate about things that should properly be left to the accountable sphere. We don't want teachers to be able to say at the bargaining table, you can't have a voucher plan. We don't want cops to be able to say at the bargaining table, we don't want a civilian review board for police shootings. Having said that, there's a lot of interesting debates about what the proper scope of bargaining in the public sector should be, and I would commend to you an article by my co-author Marty Malin called The Paradox of Public Sector Labor Law, if you haven't already seen it.
I think actually the clock is telling us this
Okay.
is where we should end. On behalf of the law school and on behalf of Sister and I guess Professor Sharp, who is the director of Sister, we have a
Should I open
gift. You can.
I would love to.
You'll find that once you, I mean, it's like babushka dolls. You open it and then there's more to open. And Scott Walker pops out. So I want to let you all know that there is a reception in the, there's nobody here to tell me. I assume in the lower rotunda, just around the corner. And please join me in thanking Professor Slater. Thank you.